Hi, folks. Dave Brown here. Um, I'm giving this lecture to give you a bit of an understanding of a few concepts that come up in law quite often. Now, these are probably best understood. You will have seen common law talked about quite a bit, I'm sure. You will have seen civil law talked about from time to time. But there is a difference between common law and civil law with big C's. It gets a bit confusing. And common law and civil law with small c's. It's about the only way of understanding what they're talking about by actually looking at the context in which it's talked about. I'll give you an example. When we talk about civil law with a big C like that, you'll find that, or common law with a big C, it could be in context with different legal systems. So within the context of different legal systems, you could say, oh, this, for instance, France is a country that has a code civil or a civil law system. On the other hand, Australia is a country that operates on the common law system, or the British legal system, English legal system it is, in fact. It inherited its legal system from England. And you can see by looking at the map, there are others there. There's Bajuridical, forget about that for the moment, that's South Africa and Rhodesia, well, those two old countries. Forgotten what they're called now. Anyway, yep, you know, that area down there. There's areas of customary law and there's Shia law, I think it is, which is the Islamic based law as well. So, and there's probably other bits of legal systems as well as, you know, there's indigenous legal systems as well in pretty much every country too. Whether they're recognised or not depends on a number of things. Anyway, essentially that's the notion behind big C civil and big C common law. It's quite interesting to look at, you know, what makes up the big C common law. What makes the British legal system, English legal system that we've inherited different from the civil system, say, of France? Well, for a start, we've got judges. They've got judges too, but we've got legislation. Hey, they've got legislation too. We've got juries, which they don't have in general. Most civil jurisdictions, civil law jurisdictions like that don't have juries. But the primary thing that's different with us is that we're adversarial and they are inquisitorial. So where adversarial means that you hire a person like a barrister who then goes and argues your case strongly, and the other party argues their case strongly, and the judge sits as an adjudicator of law, and sometimes of fact if there's no jury. Otherwise the jury decides fact, judge decides law, and that's the way it goes. Now in the civil system, what happens is, well, for a start, it sort of emanates from the Roman conquest of Europe, and then through the Bonaparte and his crowd, Napoleonic Wars in the 1800s that spread quite a lot further again. The difference with it is that it's all written down. It's written down, made by parliaments, and then it's enacted by judges. And the judges, magistrates, they're an inquisitorial magistrate. It's what's called codified. In other words, there's no common law. A judge has to do what's written down, basically. A judge doesn't have a right to make law. And so that's the notion or nature of an inquisitorial system. Although I must say, it's probably likely the judges do get their way in terms of their interpretation of the law. Nice cup of coffee. Okay, so that's the notion of civil law, code civil, but we don't need to know about that because we're not practicing in that jurisdiction, that sort of jurisdiction. Ours is all common law in the sense that it's our Australian legal system, which is inherited from England. Now there's two more divisions, right? There's civil and criminal divisions, and this is where the big C civil jurisdiction's a bit confusing because people will say, oh, that's a civil case. Doesn't mean that it's a case from France or a case from the civil jurisdictions. It means something quite different. When you look at the common law system we're at, let's have a look. We've got civil law is best understood as opposed to something else like criminal. So criminal law is punitive. It's usually the state versus the accused, and the consequence of it is that people go to jail or they get fined or have to do work orders and bits like that. It has a very high standard of proof. A burden of proof is beyond reasonable doubt against the person alleging the breach of the law. They've got to show beyond reasonable doubt that was committed. Here's an example. It might be something like a murder. On the other hand, civil law is compensatory. And what that means is that when a person gets injured or whatever, then the only thing that civil law can do is to hand out money. There's only a couple of things it can do, actually. It can sort of hand money out, or it can make injunctions, which are equitable, and we'll talk about equity later. Or it can get orders of specific performance, or it can bar people from going near other people. And there's a few things it can do, but there's mostly 99% of the time it's just handing money out in forms of compensation. It makes him or her pay to put the person back in the same position they were before the event, or if it's a contract matter, to put them back in the position that they would have been had the contract been performed. The burden of proof is on the balance of probabilities because it's not such an onerous area of law, although one could argue it's pretty bloody onerous if you're being told to pay millions of dollars, but we're not putting you away in jail or, curtailing your life. Just taking all your money. Example, someone sues someone. There's a case I found, a woman decided to sue Northwest Airlines over a knee injury she got, and that's the kind of thing that goes on that's case of negligence probably, and that would be under the civil jurisdiction. Right. Criminal, on the other hand, is punitive, so we've got those two. There's the division between the two. Even though they got big C's on them, that's just capitalisation, and that you understand the difference between civil law as a system of law and civil law as opposed to criminal law within the total system of common law, right? So we know what it does, we can go on from there. Rightio. Interestingly enough, they intersect a bit. So, for instance, you can have an act like an assault, which is both criminal and also both civilly actionable. So, a person could go to jail for an assault and could be sued by the person who they assaulted. Negligence is the same. Some cases where a person is negligent, as a result of their negligence, someone else is injured, and it's got to be proven. It's got to be shown that there is some damage. You can't claim just because you don't like it. If you demonstrate that there is damage, then they're civilly actionable in the law of negligence. But some negligence is so bad that it's considered to be criminal negligence, and that may put you in jail or fine you.